I think we'll go ahead and get started. Once again, thank you for joining us today. This is the Open Meetings Act for public body boards and staff. My name is Brandon Lewis, and I am the trial attorney here at the Office of Open Government. The Office of Open Government, along with the Office of Government Ethics, are responsible for government transparency and ethics under the Board of Ethics and Government Accountability, better known as BEGA. OOG began operations in April of 2013, and we are led by Director of Open Government, Mikkel Allen. And before we dive into this, I also just wanted to mention, if you have questions as we are going through the slides, please feel free to put them in the chat, and one of my colleagues will answer them, or if not, I will take questions at the end if you prefer to ask that way as well. Okay. The Office of Open Government interprets and monitors compliance with the Open Meetings Act, also known as the OMA, which requires that public bodies provide proper notice of, access to, and detailed records of their meetings. We provide trainings and guidance on the implementation of the DC Freedom of Information Act as well, which concerns the transparency and availability of public records. And in general, the Office of Open Government advocates for government openness and transparency. OOG provides guidance, including formal advisory opinions on compliance with the OMA. Additionally, we conduct trainings and outreach, and OOG can enforce the OMA on the basis of complaints from the public or our own investigations. And as a last resort, we may sue public bodies in DC Superior Court for injunctive or declaratory relief and/or civil fines. We're going to start with the preamble of the OMA. The public policy of the district is that all persons are entitled to full and complete information regarding the affairs of government and the actions of those who represent them. The Open Meetings Act shall be construed broadly to maximize public access to meetings. An exception shall be construed narrowly and shall permit closure of meetings only as authorized by the Act. And this comes from DC Official Code, Section 2-573, the Rules of Construction. So first off, let's discuss what constitutes a public body. Under the OMA, a public body is any government council, including the Council of the District of Columbia, board, commission, or similar entity, including an advisory body that takes official action by the vote of its members convened for such purpose. Certain groups are excluded, such as the local courts and advisory neighborhood commissions. Here's a list of entities that must adhere to the OMA: local school advisory teams, government councils, including the Council of the District of Columbia, boards, commissions, board of directors, advisory boards that take action by the vote of their members convened for such purpose, and public charter schools boards of trustees. And the following are not public bodies under the OMA: district agencies, the mayor's cabinet, and as mentioned before, advisory neighborhood commissions and the District of Columbia courts. Additionally, the professional staff of public bodies are not considered public bodies outside of a presence of a quorum of the public body that they staff. So for instance, here at BEGA, my colleagues and I are the professional staff, and we are not a public body for the purposes of the OMA unless we are at a meeting of our board. Okay. What is a meeting as defined by the OMA? It is a gathering of a quorum of a public body, whether formal or informal, regular, special, or emergency, at which the members consider, conduct, or advise on public business, including gathering information, taking testimony, discussing, deliberating, recommending, and voting, regardless whether held in person, by telephone, electronically, or by other means of communication. And then I just have a little asterisk down here to keep in mind that the and is usually interpreted as and or. And just a quick note on temporary open meetings legislative measures. I won't get too into the weeds about this, but the council has been making some changes to the OMA, which are currently temporary, but in pertinent part, what would be most relevant to you all um, is occurrences for when a meeting is open. The public body takes steps reasonably calculated to allow the public to view or hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. Meeting is not a chance or social gathering where no business is discussed. A committee or subcommittee meeting of less than a quorum of the full body, a press conference, or an email exchange. We often get questions about this, like, what if I run into my fellow board members out getting coffee or something? As long as you're not discussing public business and it's a chance encounter, that is not a meeting. Additionally, we often get questions about committees and subcommittees. So if your board or commission breaks up into committees or subcommittees, those bodies are not subject to the OMA unless they are composed of a quorum or more of the full body. So for instance, if you had a board of 6 and you have a committee of 2 members, that's fine. It doesn't trigger the OMA. But if you had, for instance, a committee of 4, at that point, you're at a quorum and the OMA is triggered. More words on quorum. This is the minimum number of members of a public body that can legally meet and conduct business. How is quorum determined? In general, a quorum is a simple majority, half of the members of a public body plus 1, unless otherwise specified by law, executive order, or other authorizing provision. The number of members needed for a quorum can vary by organization, and organizations can set their own bylaws to determine what constitutes quorum for that body. But a general rule of thumb is that it is a simple majority of the entire body. Next, we're going to discuss electronic meetings. A public body can meet via video conference, phone conference, or other electronic means if reasonable arrangements have been made to accommodate the public's right to attend. All meetings or portions of meetings are recorded. All votes are taken by roll call, and all provisions of the OMA are adhered to. How open is open? Meetings, as defined by the OMA, must be open to the public unless the OMA permits closure. And open means that it is open to the public. They are allowed to either physically be present if the meeting is occurring in person, or via electronic means if the meeting is virtual. The news media is allowed to be present, and the public body does something via television or streaming. Those are all examples of when a meeting is open. Next, we'll discuss notice of meetings, DC Official Code Section 2-576. Hey, so you should provide as much notice as possible, but notice must be given 48 hours or 2 business days before each meeting, whichever is greater. The notice must be physically posted in the office or a place that is readily accessible to the public. And notice must be posted along with the proposed agenda on the public body's website and or the district government's website, which is the central meeting calendar that is maintained on our website, open-dc.gov. And a public body must notice meetings as timely as practicable in the DC Register, except meetings of boards of trustees for public charter schools. Also, just a quick note on that. I did have a question last week with regards to the Register. Someone was asking if something hasn't been published in the Register, if they, could still fulfill the notice requirements. And we are aware that the register has its own schedule of when things are published. So while the public body must notice the meetings in the register, we realize that sometimes the register publishes about a week behind. So as long as it has been posted physically in the office, as well as on the public body's website or on our website, or both, if you want to do both our website and your public body's website as well, then notice has been satisfied. That doesn't mean that you can't or that you don't have to post it in the register. It just means that, as long as you have done the other two and have also sent the notice to the register, it's okay if that notice has not yet been published. And what does notice include? Notice must include the time, the date, the location of the meeting or a hyperlink if it's going to be virtual, and the planned agenda. Additionally, if there will be a closed portion of a meeting, the notice must include the OMA citation with the reason or reasons justifying the closure. Additionally, we ask that the following statement be included at the end of all draft and final agendas. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at open.govoffice@dc.gov. As far as to posting, notice must be posted in all of the following: in the office of the public body or a location that is readily accessible to the public, as I mentioned before, on the website of the public body or the district government, except that for emergency meetings, public bodies may either elect the usual internet posting method or post a physical paper notice in the office of the public body, the location that's readily accessible to the public. Also, again, must publish in the DC Register as timely as practicable. Next, we'll discuss emergency meetings. A public body may meet in case of an emergency. In that event, the presiding officer must clearly state the nature of the emergency and open the meeting with a statement explaining the subject of the meeting, explain how the public was provided notice of the meeting, and notice must be given to the public at the same time that it is given to the members. Emergency meetings are not special meetings. Special meetings occur outside of a public body's regular meeting schedule. The notice for a special meeting is the same as a regular meeting, as much notice as possible, but no later than 48 hours or 2 business days. Emergency meetings, by contrast, are reserved for true emergency situations or urgent matters where meetings must occur and advance notice is not possible. Emergencies include instances that pose an immediate threat to health, safety, and welfare, or destruction of property. Next, we'll discuss closed sessions, also known as executive sessions. These are governed by DC Official Code 2-575B. We tend to get a lot of questions about closed sessions. So for closed sessions, the notice should include, if feasible, a statement of intent to close the meeting or any portion of the meeting, including citations to the reason for closure under Section 2-575B, and a description of the matters to be discussed, Section 2-576.5. Closure in a meeting must include the OMA citation from DC Official Code 2-575B, the justification for closure, and a description of the matters to be discussed. I did want to note that our office is currently engaged in rulemaking on the subject of closed sessions. So I have included here a link to our website where you can see the notice of proposed rulemaking. What is pertinent from that is, in particular, is that we go into more detail about what constitutes a description of the matters to be discussed. Up until now, typically public bodies have cited the code from 2-575B and additionally read the description that was contained in the code, and not always are describing exactly what's going to be discussed. So if you take some time to read the notice of proposed rulemaking, it will give a little bit more information, but essentially we are looking for a description, a very general description of what will be discussed in closed session so that the public understands what the public body is doing. We realize that many public bodies handle confidential matters, so we're not asking that anything confidential be disclosed in the description, just something general so that the public can be informed about what is taking place in closed session. Here's some examples of closed session justifications, and then you can find a full list on the council's website, which I provided a link for at the top here. So some justifications are court order or statute, contract negotiations, or trade secrets, attorney-client privilege, which we always stress is not merely the presence of an attorney, but the presence of the attorney there specifically to advise the public body in their capacity as its attorney. Additionally, public health and safety, where disclosure would endanger the public, to prevent premature disclosure of an award, and certain admin things such as exams, personnel, or students' personal information. Next, we'll discuss the protocol for closed sessions. And I apologize, I think this type is a little bit small, but hopefully you can follow along. So start the meeting and conduct as much business as you can openly, then transition to closure. At this point, the chair must recite the reason for closure, citations for those reasons, and the subjects to be discussed while in closure. And again, as I mentioned before, subjects to be discussed should be just a general description of what's going to be discussed in the closed session. Next, take a vote of the members to move to closed session accordingly. While in the closed session, you should only be discussing matters that were noticed in the draft agenda and repeated in the chair's reading of the draft agenda. Electronic recording is still obligatory. And when the closed agenda items are exhausted, the public body should return to the public portion of the meeting and, wherever appropriate, report out any action that was taken in closure. Next, we're going to discuss recording and posting requirements. Audio recording is always required unless not feasible. And in the event that it's not feasible, it can be substituted for minutes. Video recording is not required, although we are aware that many public bodies are doing their meetings virtually. Some of them have video that they put on YouTube, etc. However, there is no video recording requirement. Transcript posted on the web no later than 3 business days after the meeting. And detailed minutes as soon as practicable, but no later than 3 business days after the meeting. Okay. From DC Official Code Section 2-578, all meetings shall be recorded, open and closed sessions. Only where a recording is not feasible, then detailed meeting minutes shall be taken. Copies of records shall be made available for public inspection. The minutes as soon as practicable, but no later than 3 business days after the meeting. For public charter schools, no later than 30 business days. And the full record must be made available as soon as practicable, but no later than 7 business days after the meeting. Just some additional information on meeting records. Detailed meeting minutes shall contain the date, time, and place of the meeting or session, the names of members of the public body recorded as either present or absent, and any motions and amendments thereto, a record of all of the votes taken, and a general description of all matters considered. If recording is not feasible, your minutes, or at least the draft version, must be publicly available no later than 3 business days after the meeting. A notation must be included at the top of any draft minutes that final minutes will be posted to the website on the next meeting date. And then, as I was mentioning, a copy of the full record, including any recording or transcript, shall be made available for public inspection as soon as practicable, but no later than 7 business days after the meeting. Just a note on public comment. We often receive complaints about this. Someone will contact us and say that they did not have the opportunity to speak at a meeting. However, no public comment period is required by the OMA or its regulations. That being said, a public body may choose to allow public comment or may have their own governing law that requires it, but public comment is beyond the scope of the OMA and our office. Brief word on complaints. An aggrieved party, including anonymous parties, may complain to OOG for relief. They may be prospective or may refer to past meetings. And except with allegations of imminent prospective violations, a public body gets 30 days to respond with a possible extension of up to 5 business days. Additionally, the director may seek to resolve the dispute through conciliation, dismiss the complaint, release an advisory opinion, or take any other step permitted by the OMA and its regulations. And just a quick note, we also mentioned that this complaint process is separate from a private right of action. So individuals may sue directly under the Sunshine Act of the District of Columbia Home Rule Act. Next, we're going to discuss duties of an administrative point of contact. So similar to Freedom of Information Officer with respect to DC FOIA, our office regards administrative points of contact as the legally responsive personnel to whom we address all OMA violations or other concerns. We ask that whenever you designate someone new as an administrative point of contact, that you report that person's name and contact information to us so that we have accurate and up-to-date information. So for instance, our office monitors public body meetings on a regular basis. So if we were to see something that we had a question about or that was a potential OMA violation, our first action would be to contact the administrative point of contact to say, hey, we noticed, for instance, if there was an agenda that didn't include the OMA language at the bottom that I mentioned earlier, then we might just reach out to an administrative point of contact and ask that they include that going forward. Similarly, any other violations, our first contact is going to be the administrative point of contact. And so for the person designated as the administrative point of contact, they should contact us for access to OOG central meeting calendar to post notices and minutes or transcripts, and they must contact us to obtain login credentials to access the user side of open-dc.gov. And then, as I mentioned earlier, the OMA also permits the use of a public body's own site for posting these records. OOG offers the central meeting calendar as an alternative and for district-wide convenience and uniformity. So while you don't have to use our website, our calendar, we certainly encourage it. Next is enforcement. OOG may bring a lawsuit in the Superior Court of the District of Columbia for injunctive and/or declaratory relief for any violations of the OMA before or after the meeting takes place. The court may order an appropriate remedy, such as requiring additional forms of notice, postponing a meeting, or a fine of up to $500 per violation. Additionally, the Director of Open Government may provide advice and training on parliamentary procedure upon request. Here it's just a QR code to the Robert's Rules Made Simple portal, which our office maintains. So you can go here and view trainings on parliamentary procedure. In addition to, of course, you may request instruction in parliamentary procedure from our office. I should also mention that these slides will be posted on our website sometime shortly after the training today, so you can refer to them there to get the QR code or any other information that we've discussed today. Additionally, our office can assist with parliamentary procedure scripts. So for common tasks, it's good to have an administrative point of contact write a script for the presiding officer to use to move smoothly through the meeting and ensure compliance with the OMA and the body's internal practices. And again, our office is happy to help assist with that. We can write scripts which you could then, tailor and modify to specifics for your particular public body, but we are always happy to assist with that. Here's just a list of sources. Our website, open-dc.gov. Additionally, on our website, we have an OMA compliance checklist, which can be helpful as a short form reference to make sure that you are doing everything you need to do to comply with the OMA. Just a link to DC official code and to the DC municipal regulations. And lastly, here's our contact information. Our office is composed of Director Mikkel Allen. Our Chief Counsel is Louis Neal. My colleagues, Anthony J. Skirbo, Attorney Advisor, Joan Lelma, Attorney Advisor, Kimberly Brown, our Paralegal Specialist, and Kevin Brown, our IT Specialist. And then again, I am Brandon Lewis. I'm the trial attorney here. And with that, I would be happy to answer any questions you may have. Sorry, I was trying to slow down a little bit, but I think I may have gone through that rather quickly. So if there was anything that I covered that you would like me to discuss in more detail, please don't hesitate to ask. I will also check the chat to see if there have been any questions.
There are no questions in the chat.
Thank you, Anthony. All right. If there are no questions, I will give you back the rest of your afternoon, but I will stick around for a few more minutes in case anyone has a question that suddenly pops into their head or that you've been mulling over. I'll stick around for probably another 5 minutes on here, but you are welcome to carry on with your afternoon.
Thank you.
Oh, you're most welcome.
Thank you.
Thank you very much.
You are all very, very welcome. Also, if you think of any questions later, you can always reach out to us at the email addresses that were in the presentation, and we'll be happy to assist you.